Ms. Vora is ranked in the Legal 500 UK for the year 2020 and 21 as a leading individual for commercial litigation. Ms. Vora is an alumnus of Government Law College and was a member of our student council. During the beginning of her legal career, Ms. Vora had shadowed Mr. Dwarkadas for a year, worked as an associate with Wadia Gandhi and Co. for 4 years, after which she worked as a junior in the chambers of Mr. Andhyarujina at the Bombay High Court. She was then called to the bar by Gray's Inn in 2011. Before her time at GLC, Ms. Vora completed her BSc in Management Sciences from the London School of Economics and Political Science. She also taught commercial law at the summer school at LSE. Dear Madam, we are honored to welcome you here today.
Thank you. Thank you so much, Aditya. Thank you, Government Law College. It's a real pleasure to be back. And Sanchi also for organizing me to organizing this morning's lecture. I'm not sure how many students wake up on a Sunday morning, but here we are, and thankfully it's being recorded for those who have had a great Saturday night out. So it was just over 20 years ago when I was where some of you are, starting off at GLC. And if someone said to me on the first day of my LLB that I would be delivering a speech to a later batch of students at GLC, I would have dismissed their kind suggestion as an impossibility. But that, dear students, is the power of perseverance and hard work. Now, before I deep dive into my speech, perhaps I should tell you a little bit about what I do. So some of you may be familiar of the difference between a counsel and those who work in law firms. I am a counsel, and I have a set of chambers in both Mumbai, and I'm a member of a set of chambers in London, 39 Essex. And we're known as barristers in London. So we're the lawyers who actually argue in court. And we're slightly different from those who are disputes lawyers and work in law firms. Those who work in law firms have sort of client-facing, a client-facing side, and they have a deeper understanding of the facts of the matter, and they generally tend to prepare in preparing the case, preparing the documents, sending out notices to the other side, filing documents in court, and also preparing a brief for a counsel such as me. And when the brief lands at my desk, it tends to be a brief to draft the pleading that will be filed in court. Or perhaps if the pleading has already been drafted, then to make arguments in court. Now, what did my day look like? It was very different as a counsel at the Bombay High Court and rather different in London. At the Bombay High Court, I used to be up at about 4:30 or 5 every morning, read my papers for the day, be in chambers by about 9:45, and meet with clients as and when necessary, be in court from 11 to, I think it was 4:45 then, and then 5 after some time. Again, return to chambers between 5 and 7, have a further set of meetings, read papers for the next day, etc., and then be back at work at my desk in the morning at about 5 a.m. In London, it's rather different and a lot less rigorous, because there aren't as many cases at the commercial courts in London as there are in Mumbai, and I am a commercial law practitioner. So in London, a busy commercial law practitioner can go to court maybe once a month, and it can be anything ranging from, say, a half-day interim application or a PTR, as they are called, pre-trial reviews, or it can be a trial that lasts a few weeks. And sometimes, if it's a really heavy trial, but it would be odd for a junior counsel to be involved in that. A trial can even go on for as long as 3 months. So in London, I would be at my desk mostly and working on papers. So for example, preparing for a trial that would be coming up. And the rule that we tend to follow is that for every hour or every day spent in court, you need to spend 3 days or 3 hours on your papers preparing at your desk. So rather different. And I think that can also be summarized by an experience. One of my, I had done what is called marshalling, which is the equivalent of an internship with a Court of Appeal judge in London. That's the equivalent of a division bench in Mumbai. And this was in my early days when I had just relocated to London. And he said he made me wait and called me during a busy week. And during that busy week, he had 3 matters on board and 2 full reading days. And of the 3 matters, the maximum amount of time spent in court was 2 hours for the matter that lasted the longest time. So it really is a very different system from the Bombay High Court and what you may be familiar with. Now, how did it all begin? It actually began when I was a student of BSc at the London School of Economics. It wasn't an LLB. And I took an outside option in law, and it was taught by Professor Hugh Collins. It was commercial and contract law. He later went on to become the Vinerian professor at Oxford. And he basically said contracts are everywhere. Whether you go into a grocery store to buy something, or you jump on a bus or a train to get anywhere, the bus ticket or the train ticket is a contract between you and the bus company. And my view of the world completely changed when I saw that. And I couldn't understand how anyone who had not studied contract law lived or functioned in today's world. So that really prompted my interest in the law. And it was, of course, much to the horror of my parents, who were, they thought, well, you've topped your school and your college, you have scholarship to the LSE, and now you want to drop it all and go and pursue law. So I continued, finished my BSc, came back, and I did a second degree, which was a 3-year degree at Government Law College. I think I began in 2003 and graduated in 2006. And I thoroughly enjoyed my time there. And it all happened when I came back. I think it was August when I returned. So college had already begun, admissions had closed in June. And the principal at the time was horrified that a student even dared to come and seek admission in August. But I was just, this is the theme of the talk today, I just persevered. And so basically came and sat outside the principal's office for the major part of the week that I had returned from London. And thankfully somebody dropped out and I was given the place, and that's really how I got into Government Law College. My exam results from the LSE came later, but when they did come, the principal was thoroughly pleased, because she would have been very happy to have admitted me had I joined the June admissions. Now, this perseverance is really the great part about loving what one does. And it doesn't matter what anyone else says, because if you love what you do, then you will persevere through every obstacle that comes your way. Now, on the first day at GLC, of course, I thought of all of the differences in infrastructure and the complete mismatch between the 7th-floor library at the London School of Economics and Government Law College. But one has to really look at whatever situation they're in and think about what is positive that can come out of that situation. So for example, Government Law College had, and I think it still does have, a great mooting culture. And frankly, that mooting culture is second to none nowhere else in the world. And so I spent a lot of time mooting, and I would very much encourage all of you to do that. Because I came across all sorts of areas of law that I did not practice later in life, such as personal negligence, medical injuries, and so on. And I'll try to explain by way of a couple of examples that knowledge is really never wasted. And no matter what kind of moot court that you face or what kind of matter you now face, it is an opportunity that has been put your way, and an opportunity should never be lost. So for example, when I was quite young, and perhaps I should complete the journey. So Government Law College, and then worked at the Bombay High Court. I signed my articles with Vadya Gandhi and then worked as a counsel. So all of that was about 6 years before I relocated to London in 2009 and requalified to the bar and joined. So I did pupillage at Fountain Court. Pupillage is compulsory before one can become a practicing barrister. And thereafter joined 4 and 5 Grayson Square, where I was for many years, before moving to 39 Essex, where I am today. In fact, I just moved in the middle of the lockdown. So when I arrived as a junior counsel at 4 and 5 Grayson Square, I said to them, look, I come from a system, the Bombay High Court, where I have fantastic advocacy experience, perhaps a fair bit more than most counsels would in London, certainly commercial law counsels. And so I'm happy with my advocacy experience, but it was an applications driven system and not a trial system. So can you please give me some trial experience? And they said, well, it's impossible to give you trial experience in the commercial law field, but what we can do is make you standing counsel in the immigration tribunals. And I said yes to that. And it wasn't an area of law I was interested in or even knew much about when I ventured into that field. And I did a fair number of maybe about 200 immigration trials in the span of the first 2 years of my legal career. It doesn't appear on my CV because, again, I always wanted to come back to commercial law. But the point is the opportunity that it put my way, which really was something that was not worth missing out on. And then all of these years later, that opportunity has come a full circle. And many of you would have read cases that are ongoing in English courts that deal with Indian individuals, such as Mr. Malia or Nirav Modi, and then there are many others that actually don't appear on the first page or the front pages and are tucked away in the inner sections. And these economic fugitives, as they are called in India, tend to arrive in London and have 3 parallel proceedings. So they would tend to have a worldwide freezing injunction against them. That's also called a Mareva injunction in Bombay. And that's the commercial law aspect of it. So something that I do day in and day out. Then there is an extradition trial, which is a purely criminal process and goes through the magistrates' courts in London. And there's a third process which actually never hits the headlines because it's a completely confidential process called Asylum. And so these individuals would be seeking asylum in the United Kingdom, perhaps on the grounds that they risk or they are fearful of persecution when they are returned to India. And they say on those grounds, whether it be political persecution or otherwise, they should be granted asylum or a refugee status to remain in the United Kingdom. Now that is an immigration trial, and it's a purely immigration trial that goes through the system. And what I'm trying to explain is because I said yes to the cases, to immigration trials when I was a much younger lawyer, I am now suddenly able to assist very seamlessly on matters such as this. So one really doesn't know when the world comes around in a full circle and the kind of opportunities that you would have taken up in your earlier days may come around to help you in later life. Another example of this is as an article clerk at Wadia Gandhi, and it was such a fantastic firm with rotation, a good solid rotation system. So we had 1 year of corporate law, 1 year of conveyancing, and 1 year of litigation. I always had my mindset on litigation, and so I was very bored all through my corporate law rotation. And the year that I spent working on this massive shareholder agreement, it was a private equity agreement, I didn't understand why anyone would want to be a lawyer and not go to court, and why they would want to flip the pages of maybe over 100 pages of a shareholder agreement. And what happened next? So many years later, when I became a specialist in commercial law, I ended up being, and I still am, a shareholder disputes specialist. So exactly the kind of agreements that I drafted when I was an article clerk at Wadia Gandhi are the kind of matters that land at my desk today. And I'm all the better a disputes lawyer because I said yes and I took on those opportunities in the earlier days. So dear students, what I am trying to say is please say yes to every opportunity that comes your way. And don't worry about what it is that you would like to specialize in, because a specialization will eventually happen. Now, I remember my head of chambers actually at 4 and 5 Brazen Square had said to me, if someone had, he's now an election law specialist, one of the best in the United Kingdom, and also planning law specialist and so on. And he said, well, Karishma, if I was told that you need to become a law specialist when I was much younger, I would not have known how to do it. It's just because life happened that way. And I took every opportunity that came my way. I said yes to most briefs that came my way, and therefore ended up along this path and became a specialist. And that is also the message that I would like to give you. So the opportunities that may be coming your way now may be moot courts, various organizations such as the Alumni Association, who has organized this lecture today, and others. Now, one of the others that I think where one can really create an opportunity if there is none is the Legal Aid Society. I hope that still exists at Government Law College. They were quite active back in the day, and I remember assisting and going down to the consumer court a fair bit, and really summarizing, reading through the briefs and summarizing the papers and my view of the papers for the judge, so that the judge only needed to read perhaps 1 or 2 pages that I had written rather than the full briefs that were on his or her desk. And the judges really found it extremely useful. And it was good experience for me to get acquainted with the pleadings in the matters and the way in which a matter develops in Mumbai. So that's another way in which one can create opportunities. Now, another way of creating opportunities is if you already have an internship or you are already an article clerk, then make it known to your court clerks that you would be very willing to go to court. So for example, at my time again at Wadaya Gandhi, the clerks knew that I would go to court at the drop of a hat. I mean, whether it was an application to change names. So for example, I think Credit Agricole Bank had become Callion Bank in those times. And so it was just a simple name change application, but it required an amendment application, a chamber summons, and going down to court to make the chamber summons or argue it. Ranging from that to complex summary suits, because we had a lot of banks as clients, etc. All of those would end up landing at my desk, and slowly at 7 p.m. every evening, the little pile of briefs became bigger and bigger and bigger. And that was to the dismay, perhaps, of some of my colleagues who refused work, thinking that, oh, this is too small for them to do, and only tried to accept the juicier work. But, life doesn't work out that way. So the clerks will not think of you if you're not willing to accept everything that they want to put your way. So it really is in everyone's best interest to just say yes. And that is how one also creates opportunities. Also, I'd say be a generalist in your younger days. And I think it is very rare that a brief that lands at a lawyer's desk, no matter where in the world, will only have one aspect of law. For example, if it's a commercial law brief, it may also have an insolvency angle, it may have a tax angle. The examples I gave to you earlier contain threefold. So they can a commercial law angle, the freezing injunction, an immigration angle, the asylum application, and a criminal angle, the extradition hearing. And likewise, all briefs that land at your desk or that you may come across will have more than one angle. And you will be all the better a lawyer if you would have been a generalist in your younger days. So this is your time to experiment and also get acquainted with different areas of law, because that will make you a better lawyer, and you will be able to approach a brief holistically when it lands at your desk a few years into your career. Also, do pro bono work. And I think that brings me back to the legal aid point. There are thousands, if not lakhs of people in India facing legal problems and who really feel vulnerable because they don't know how to handle their case. They may have their own lawyers, and the lawyers may be competent. Sometimes they are not. Sometimes they are competent, but they're so overwhelmed with work that they just haven't had a chance to look through that individual's case in a detailed fashion. And this is where you come in as a student, because student life is perhaps the only time in your lives where you will be time rich, and that can be used to assist others. And this, of course, is creating an opportunity for yourself by doing pro bono work, but also assisting others. And that really is a win win situation for society at large. So, whatever you do, the point is try and be of genuine assistance. Think about what will be needed in the matter and present that idea to the person you're working with, whether it is the client directly or an associate or a partner in the law firm, and ask them if you can carry out that task. Don't be afraid of failure. Failure is not the opposite of success. The opposite of success is learning. I am a first generation lawyer. And when I moved from Bombay to London, it was the peak of the recession, and it was the summer following the fall of Lehman Brothers. And I had been a pretty successful counsel at the Bombay High Court. But when I moved to London, it was just devastating because it was impossible to get work, very tough to requalify. And when I landed, I didn't even know the difference between the words barrister and solicitor. So I was really starting from scratch. The only opportunity that came my way was a paralegal position. And this was such an ego-crushing experience because I thought, a pretty successful counsel at the Bombay High Court. And I was in a place where I could even refuse briefs because I had such good work. But there was no other opportunity in London, and so I had to take on what was this paralegal position. It basically consisted of working for a large pensions fund in the UK, and a team of us had been drummed up to go through thousands and thousands of documents. And all we needed to do was go through the documents and mark which ones were relevant to be disclosed to the other side. So this is the equivalent of what in Bombay we used to call inspection. And the exercise is more rigorous in the UK, and it's called disclosure. And then we had to sift out from those documents that were relevant, those that were not disclosable by either way of privilege, because it was communication between the client and the lawyers, or had a without prejudice on it, and so was without prejudice communication, which would not need to be disclosed to the court. And this exercise actually also taught me various things about the trial system in London and how matters develop between interim hearings and the final trial stage. And again, this was not failure, however ego-crushing it was. It really was a learning opportunity. And then that slowly led to many pupilages. Many pupilages are internships in London. And those then led to my final pupillage at Fountain Court, and then a tenancy, which is being a permanent member of a set of chambers in London. And the reason it's called a tenancy is because we contribute to rent and expenses from the day that we join. So the point is that the journey as a counsel from the Bombay High Court to the Royal Courts of Justice in England was ridden with hurdles. And I did not get what I wanted or desired at every step of the way. But treating everything as an opportunity to learn is how I got on, and perseverance and hard work combined. I learned quite a lot. For example, I learned about the law, but I also learned how to deal with clients and what not to say before both the judges in England as well as clients. It is not necessary that everything in life comes at the time that you want. So you might have to be patient and keep working hard in the meantime. The other things, so perseverance and hard work are two key features of any lawyer's life. But also, I would very much like for all of you to be kind and to have empathy. Remember that everyone is replaceable in the legal world. There were some fantastic judges and lawyers, the greats of their times in the 19th century. And then those were replaced after they passed in the 20th century. And those are now replaced in the 21st century, and so on and so forth. but you will never be replaceable with your friends and your family. And so make good friends and be kind to your elders and be helpful in your family. Now, in your friend circle, it is very important to be a good listener. Listen when the other side is talking. There will be thoughts that come into your mind. Let those thoughts come and let them go. Don't hold on to those thoughts, because the moment you do, you will stop listening and perhaps become the kind of person whose response really doesn't answer what the other side has just said. And so that has happened because you stopped listening 2 minutes ago when that thought entered your mind. Improving listening skills is rather important starting from your younger days, because it's also very important in court. You will have to listen to what the other side has said before you can counter their arguments, and you will have to listen to what the judge says before responding. Likewise, it's extremely important that you listen to both sides of the debate before making up your mind, and you be balanced in your approach. I think it's rather unfortunate that our country has become very polarized recently. Perhaps this is also true for most countries around the world. And there was an interesting film on Netflix called The Social Dilemma that you may want to watch that explains this. But focusing and keeping the focus on India at the moment, from the Citizenship Amendment Bill to the celebration of the Ram Janmabhoomi and so on, every issue seems to have gotten polarized. And it's a little ironic that the polarization is on account of or on grounds of secularization or being secular, because really that should be uniting the country. But the term secularism is dividing our country as on today. And so why not think of another way in which the society can benefit and be more tolerant? For example, what about the word tolerance instead of the word secular? Wouldn't that be a better achievement for our society rather than being secular? Let me give you an example. So I learned after moving to England that England was not a secular country, or rather the United Kingdom is not a secular country, and that it follows the Church of England. In fact, I learned that most countries around the world are not secular, and so India is really unique in that respect. And the Queen celebrates various services, various occasions around the year by services, where she goes into the Westminster Abbey and performs a service. And on these occasions, the whole country, including me, and I'm not Christian, just is tolerant and celebrates in the country's celebrations. And wouldn't that be a nice thing to do rather than question why something is being celebrated? Why not celebrate with everybody else? And why not be more tolerant? I think it really is important to bring back tolerance in student life. And I met, in fact, and the reason I say this is because I met a couple of students from Government Law College recently who said it's just impossible to talk about politics because everything is so divided, whether for the government or against the government. But the whole point is that when one holds any view, whether political or otherwise, it's important to not believe in it completely. Because it's only when you don't believe in it completely that you may be open to listening to views of the other side. And so on social media, if you're following a particular side, make sure to also follow people and journalists who are of the, like if you are a left-wing person, make sure you follow somebody who is right-winged. And if you're right-winged, then you make sure you follow somebody who is left-winged. Because that is the only way in which you will be able to keep an open mind. Otherwise, the only thing that you will be exposed to will be one side of the debate, and that cannot be healthy, and that promotes intolerance. It was at the start of this year a very sad few days for India, and the riots in Delhi saw people lose some of their lives, and I think all of us, no matter which side of the debate we are on, would agree that our hearts go out to those who lost their lives in the riots. Now, if I may, without getting into the politics of it, and here again, my experience from my immigration days comes into play. just give you a brief background of how asylum applications are conducted in the United Kingdom. Because really, this was all about that. It was about whether or not India should allow refugees or asylum seekers to be granted citizenship status in India. So I don't want to get into the politics of it, but let me tell you the legal side. In England, when somebody applies for asylum, they have to go through an extremely rigorous process. So they have to make an application to the Home Office, and they go through two sets of interviews, which are again the first interview is all right, but the second interview is quite rigorous. And the Home Office then decides on paper whether or not this individual will be granted asylum. If the individual is not granted asylum, they have the right to appeal to the first-tier immigration tribunal, and thereon to the upper tribunal, and from there on to the High Court on judicial review, which is the equivalent of a writ. Now, what is the criteria for being granted asylum? If anyone were to come to England or to the United Kingdom and say, I want to come here because I come from a country in Africa or wherever else, and I don't have quite as much in terms of economic opportunity, and therefore I would like to be granted asylum in the United Kingdom because I think that I have a better chance of breadwinning for myself and my family. That, dear students, is not a good reason for asylum. And in fact, that is a reason or a ground on which the the Home Office rejects asylum in the United Kingdom. So it can only be on grounds of persecution and real solid evidence of persecution. The highest asylum applicants at my time, and this was, I think, around 2010, so about 10 years ago, were from Sri Lanka. So this is asylum seekers from all over the world. And in the United Kingdom, we saw asylum applications from Albania. Because of blood feuds in Albania, we got people from Pakistan who said, we're Christians in Pakistan, and we are not allowed to freely follow Christianity in Pakistan, and we are minorities, and therefore we'd like to move to the United Kingdom. And then we had Hindus or Tamils from Sri Lanka who came to the UK and said, please can you grant us asylum, because we were part of the LTTE, and even though we were in a really perhaps in a small capacity and worked in a small capacity, we were told to surrender to the Sinhalese army, and unfortunately, although we were promised that nothing would happen, we were actually put in concentration camps. There's a really good movie about this called Madras Cafe by John Abraham, and it only touches upon what I have seen in person at the immigration tribunals in London. So the point really is that these people, if they were returned to those countries, would face a great deal of difficulty in the sense they could be persecuted, they could face, they were at risk of very serious physical harm and possibly death. And these were the reasons that were sufficient to grant asylum or for a refugee status to be granted in the United Kingdom. And all of this needs to be borne in mind when one looks at the Citizenship Amendment Bill in India, and I would urge you to do so. And it's important to sort of be aware of all of this before deciding whether or not you want to fight about it. And this does have its roots in student life. So please talk to your peers, talk to your friends who don't have the same political views as you, and make sure that you are both listening to what the other side has to say to be a more tolerant person for society. Now, that's my sort of sermon for the day. But I thought I would also just share with you a few lessons and share with you a few other more fun things that I have learned by gaining experience overseas. So I guess what I learned abroad can be summed up in one incident that occurred at the very start of my legal career. And this is when I had left behind, as I've said previously, 6 years of experience at the Bombay High Court, and I was riding high. I thought I was successful enough, etc. I was appreciated, and I thought my drafting skills were good because I was told by senior counsels and others that they really liked my drafting. And then I go and submit my first piece of work in London. And I remember it was to an individual who was the head of the department then at Fladgate, called Simon Eakins, and we're still very good friends. And he looked down at my draft and up at me, and he said, "But Karishma, this is not even English." And then there it all began. So I had to unlearn everything that I had learned at Government Law College, at the Bombay High Court, and relearn it the English way. So there are many reasons, I guess, that one may want to live and work abroad. And one of them is certainly improved communication skills and soft skills. The time spent working abroad improves all of this. For example, it is not a plaint, it is a claim. The English system has done away with Latin, and so we don't use words such as plaint. We don't use words such as inter alia. We say amongst other things. At work, it is not a tiffin. It is certainly not a dabba. It's lunch, not even a lunch box. I live in London. I do not stay in London. And so soft skills. So for example, when I land in London, I have to sort of realign my system, my way of thinking, and address my clerks. So for example, I would say, Mark, if you don't mind, when you have a moment, please could you put some paper into the printer because it has run out. But when I come to India and I tried it, and I said, Arun ji, jab समय मिलने पर अगर आपको कोई इतराज नहीं हो तो थोड़ा पेपर प्रिंटर में डाल दीजिए. And he looked at me dumbfounded because that's just not the culture in India, is it? And he said, Madam, आपको सिर्फ बोलना है कि पेपर डाल दो, that's it. So soft skills are a really important learning lesson from working abroad. The second, and this is my favorite, is working with technology. And there are all sorts of things. So for example, when I was working in a law firm for a short duration, there was a clock. So there's an app on our, and this was 10 years ago, so it was rather different from the days that we are seeing today. There was a clock on our desktop which would list all of the matters that we were working on. So for example, if I get in the morning and I'm working on matter A, I would just click on that and the clock would start ticking on matter A. If in the middle of that, a client from matter B gave me a ring, I would pick up the phone, but I would also just move to matter B. The clock on matter A would stop ticking because obviously you can only work on one matter at a time, and the matter B would start, clocking its time. And likewise, it progressed through the day. And at the end of the day, it just developed a timesheet for me, which said how much time I have worked on each matter. And that would be very useful at the end of the month because the bills would be automatically generated. Now, there are other issues concerning technology, which are really, going to be much more relevant in your practice, perhaps, than mine. And these concern crypto assets, smart contracts, and other sort of cyber crime. So, for example, I'll give you, an example of international trade fraud, which has happened fairly regularly over the last few years. So, if a seller from, let's say, China is selling machines to India, and they email an invoice over. Let's say the order was for 10 machines, and every invoice that arrived, the Indian company made the payment in time. Now, in the 9th invoice, somebody who hacks the system is able to hack and just modify one letter of the email address and make the invoice look as though it was exactly like the original invoice, but it would have completely different bank details. And unfortunately, the Indian company would not realize that this one letter has been changed and otherwise everything looks the same, and would make payment to an incorrect bank account. Now, it's very difficult to handle cases such as this because one doesn't know who it is who was the perpetrator behind the fraud. And banks tend not to give out those their details for data privacy reasons. And so English courts have taken on, quite a practical view and have in the recent past started pronouncing judgments against persons unknown. So this means that you can go through the entire trial, you can explain what it is that has occurred, and the whole trial will not be against Mr. X or ABC company, it will be against persons unknown. And when you get the judgment in the end, you can take it to your bank, and or not your bank, but the bank to which the money was transferred, and say, here we now have a judgment, can you please reveal the identity of the person who was behind the fraud, so that we can go behind them. This is just one example. Other examples of technology are also included in artificial intelligence. So for example, there is a real problem that lawyers are not going to be needed, and none of us will be needed in the long run. So in Australia, for example, a family court, and you will learn this if you have or know this, if you've done family law internships, they have mediators in every family court around the world, or at least in most of them. And Australia also has mediators, Indian family courts have mediators, etc. And the mediator was replaced with an artificial intelligence software. And parties have now started submitting their disputes to the software and are settling on the basis of whatever decision is being made by this artificial intelligence mediator. So the judges no longer are flooded with the kind of matters that they used to be flooded with. And this has also happened because during the testing phase, they realized that the AI mediator matches the judge's decisions about 90% of the time. And you can Google this and read about it. So the judge in that instance, or rather the mediator in that instance, because we're still on baby steps, the mediator was replaced by an AI judge. You may be familiar with eBay, and eBay has resolved, I believe, upwards of 60 million disputes between sellers and buyers by way of artificial intelligence dispute resolution. So really, this problem is quite serious, and it also brings me, or it's not a problem that is serious, but it is really what society is coming to, and the direction in which legal working can move. And the task I told you about at the beginning of this lecture, where I arrived and I had to do paralegal work in England, and I did what is known as a disclosure exercise. So that has completely been replaced by artificial intelligence. You don't need junior lawyers anymore to sort of go through and click through every single document and say which ones are relevant to the matter, which ones are not, etc. Most of that task can be done by artificial intelligence now. And so be open to change. We are living in fast moving times, and you will be lucky if you go through your entire life only having pursued one career. There is a book called The 100-Year Life, and it basically talks about the changing times we live in, where people live longer, and there is a need in someone's 50, when they're 50 or in their 50s or 60s, to go back to education and teach themselves a new skill, because things would have changed so drastically by the time they were in college to the time that they were 50 or 60, that they would need to teach themselves to be able to go back to work in another career, perhaps, to sustain their life until they're, especially if they live until their late 80s or so. And so in the words of Mark Antony from Julius Caesar, there comes a tide in the affairs of men, which, if taken at flood, leads on to fortune. The tide, dear students, is in favor of change. And so be open to change and propel yourself forward by taking on every opportunity that comes your way. The next sort of aspect about living abroad and an experience that one gains by living abroad is also to identify what not to adapt when they come back to their home country. Brexit is a real great example of this. And Jonathan Sumption, who is a retired Supreme Court judge of England and Wales, has written articles about how referendums in parliamentary democracy have no place, because it requires the parliament to really tightrope when they don't agree with the referendum. And he described the situation as walking on a tightrope sometimes when there is no rope at all. And the results of a referendum have no place really in a parliamentary democracy, because it's not like the referendum is the law. It has still to go through parliament. The next reason is significant personal development, because one is forced outside their comfort zone when they live in a foreign environment. And this really doesn't necessarily have to be when working abroad. It can be a student of Bombay going to Chennai to work, or going to Jabalpur or Delhi to work. And that also is a kind of immigration. And that requires the person to really accept wholeheartedly the place that they're living in, and sort of merge in before emerging as the one who stands out. So you need to have your feet firmly on the ground before you fly. The last point, and this is rather an important one, is discipline. I recall my student days in London when there was just such a distinct divide between students, between sort of the students of the subcontinent, including India, and European students. So students of the subcontinent were in the library 24/7. They were just in the library. They didn't really have a life outside of work or outside of studying. And as compared to that, the European students were in the library perhaps at 9 a.m., having already finished, let's say, an hour of cycling or an hour of rowing in the morning before reaching or arriving at the library. They'd work or study from 9 to, let's say, about 6 or 7 in the evening, and then they'd head down to the pub for a pint or go out with their friends to play football, or have a meal at a restaurant, etc. But basically, they had their evenings off. And this is actually a great discipline to inculcate during student life, because it takes you through your career, and it allows a well-rounded personality that can handle work as well as family life, and really other passions as well. And during a speech I made earlier this year to GAR, the Global Arbitration Review, and if you're interested in arbitration, you must follow it, Global Arbitration Review. At a conference they had in Delhi pre-lockdown in February, I said working from home is really an important part of the fact that some cultures just inculcate discipline and others don't. So working from home is very common in London, and many barristers would work from home a few days a week or a couple of days a week if they had small children that they needed to look after, or they had old parents that they needed to care for, etc. And despite working from home, they would produce about 8 to 10 hours of billable work every day. And that was only possible because they were disciplined. Of course, now I feel vindicated because everyone is working from home. And it's great. It's great for young mothers who need to stay at home to look after their children. It's also great for people who need to support older parents. And I mean, there are just an infinite number of possibilities and positives that come out of working from home. But it can only happen if you are disciplined in your life. And this is the time to inculcate that discipline. So remember that you must, while being disciplined, also be 15 minutes early for every appointment. If you're 5 minutes early for an appointment, then you're 10 minutes too late. So in conclusion, it has been an immensely fulfilling journey for me from the Bombay High Court to the Royal Courts of Justice. And I hope that my journey demonstrates that you can do it too, provided that you persevere and you work hard. Thank you.
Thank you, ma'am, for that very insightful and practical speech. We will now be taking some questions which we have in the chat box. So I can read them out to you and maybe you could answer them.
Sure.
The first question that we have is, what are some of the small amusing details that stand out to you when you practice law in India and in the UK?
I think the advocacy, I mean, the style of advocacy. So I remember sometimes going into the High Court in Bombay, and it was just completely filled with people. And you're sort of arguing from the back, trying to have your voice heard and making your way to the front and trying to find space. And that is completely different from London, because the only parties who are in court in London are the parties who are concerned with the case. And that's it, nobody else, because there would have been a preset timetable. For example, if I have, and I do have a case, a trial coming up in January in London, and that has been in my diary for about 14 months. So I have known 14 months ago that these are the dates, these are the 9 days of trial in January, and that's it. And nobody else is going to be in the court other than the judge, my instructing solicitors, and me, and the other side, and their instructing solicitors. So there's no drama, there's no chaos, and I think that is also what I miss about working in India.
The next question is, what do you think of the usability of the AI judges in Indian landscape?
I think there is a fantastic possibility, especially, and we should start with the smaller disputes. So there must be so many people who have, who are owed, let's say, 50,000 rupees or less, or maybe 1 lakh rupees or less, and then just have all of those disputes resolved through a small claims procedure, which is just completely on AI. I think that's possible, and it would significantly help people who otherwise are scared of going into the system, into the legal system, because they think that they will end up spending more than the amount that they have to recover.
Ma'am, the next question is, could you share some of your experience in international arbitration?
Yes, I mean, some of my experience. So why don't I just give you an example on a no names basis? There is a very large private equity group in Europe, and they made an investment into an Indian company, and the Indian company set up what is known as SPV, which is an operating company in India, and they were in a particular industry sector in India. And a few months into this shareholder agreement, which was worth about upwards of 200 million US dollars, there were disputes because the style of running a business that Indians have, especially Indian-run family businesses who have suddenly opened up to accepting foreign private equity investment, is completely different. So the Indian functioning of a business would clashed with the private equity sort of professionalism. And this is not uncommon, this happens quite regularly. And so one party went to then the company law tribunal, and now it's of course the NCLT, and said that this is, they went under oppression and mismanagement, and they said all of this is a difficulty with the operating company, which is an Indian company, and it's between shareholders of an Indian company, and therefore the courts should have jurisdiction to hear this matter. On the other hand, the other party invoked arbitration, and it was an LCI arbitration seated in London, and they said, no, this is not something that is between the shareholders and directors of an Indian company. It really is coming out of the shareholder agreement, which has as its dispute resolution clause arbitration seated in London, governed by English law. And then this also, we had to make arguments about whether or not the Indian proceedings were dressed up to actually be portrayed as Indian proceedings only, when actually they were arbitration proceedings, and we won on that ground. And so they were held to be arbitration proceedings. But then there are all sorts of difficulties, because if you have an anti-suit injunction which has been passed by a arbitration tribunal, it is not, because it's not enforceable, because interim orders of international arbitration or just arbitration generally, forget international arbitration, are not enforceable under the New York Convention. So we then had to make the argument that, and this is true as a matter of principle, that anti-suit injunctions only restrict parties to the anti-suit injunction. They actually don't restrict or limit or interfere with the courts of a foreign jurisdiction. because indeed an arbitration tribunal has, or even if it were a court of another country, it doesn't have the right to interfere with courts of another country. The maximum that it can do is to restrict the parties that are before it, to prevent them from litigating elsewhere. So this is just one example, but I have seen recently in most of my arbitration cases, one leg of the dispute tends to be in the Indian courts, whether at the NCLT or otherwise, and another leg of the dispute tends to be before the arbitration.
Thank you, ma'am. The next question is, how daunting was it to move to London at the peak of recession? And did any second thoughts emerge considering the almost dystopic economic conditions around the world?
Yeah, so it wasn't daunting because when you are ignorant and you don't know how bad it is, you just this is the great thing about being young. You just think you know everything, and you just land up and you just hit the ground running. But yes, when you hit the ground running, then it hits you, and then you think, oh goodness, what have I gotten myself into? And yes, actually, I did. I had many second thoughts on whether I wanted to move back to India, but I persevered because I thought I just want to requalify. I want the experience, and then I'll move back. Of course, that never happened. And now I straddle two jurisdictions. But what did happen is that I now spend about 3 to 4 months of the year in Mumbai, and I spend the rest of my time in London. So it's the English court vacations when I come to Bombay around December, January, and August, September, and that's when I work out of my chambers in Bombay. Of course, COVID has been an anomaly. And then the remaining time I work in London. So it's a good time to be missing from London, to be away from there during the court vacations. And it also enables this real cross-border practice to continue. And I can therefore meet my clients. A lot of them are Indian individuals and Indian companies who find themselves in English law disputes. So that's so the second thought then converted into how can I make this work? And then, this is how I ended up making it work.
Thank you, ma'am. The next question is, are there any British professional practices that you would like to import to the Indian workplace?
Discipline. And really the work-life balance. So we would be in chambers in London by around definitely 9 a.m., if not earlier. And we would be done by maybe about 6 or 7 p.m. So all of this, working long hours, staying in office until midnight, and this great Indian law firm work culture can completely be done away with if there's a lot more that occurs during the early hours of the morning, and you get that done. Because frankly, everybody deserves a family life and everybody deserves a social life, and that's the only way in which it can sort of be balanced. Oh, but also, of course, the other thing is drafting. And every time I get an Indian draft on my table, I just think, oh, why, first of all, is there a need to repeat everything? There's just no need. You've said it once, there is no need to repeat it over and over again. Secondly, whatever you say in 2 paragraphs can generally be said in 2 sentences. So why, say it in 2 paragraphs if it can be condensed? And third, be very careful about the kind of allegations that one puts in. I mean, everything is put in, including, this is not it. Instead of just saying this is a breach of contract, this is the clause that has been breached, and therefore, liquidated damages or damages of so much is owed. Going to the extent of saying, oh, but it's also cheating, it is conspiracy, and it is fraud, and it is, throwing everything in the kitchen sink at it. There is no need to do that because you can get, just by way of saying simple breach of contract in most instances, what you really desire, unless you want to and you are also bringing on a parallel criminal proceeding in order to, put some strategic pressure to bring the other side to the negotiating table or something. So as far as drafting is concerned, be careful. And in fact, this is really, this is ingrained in us because when we go through our barristerial advocacy skills drafting, we're told that we cannot, as an English barrister, put our name to a draft where there is the word fraud in the draft if we have not seen evidence of the fraud. So we have to, see evidence, and only if we're satisfied that that evidence is sufficient to allege fraud, then we use that word. Otherwise, it doesn't go in. And this is a matter of professional ethics as far as English barristers are concerned.
The last question for today is, reading is something everyone stresses upon a lot, and could you suggest some good works of literature on arbitration or other law subjects?
There's a great book on advocacy called The Art of the Advocate by Richard Ducan. That is a good book to sort of read as far as advocacy is concerned. For written drafting skills, there's a book that is called Pleading Without Tears, and that's a good book. And then there is a recent book which I think I'm is also close to my heart because he's a member of my chambers. Lord Dyson is a member of 39 Essex Chambers, and he's written a book recently, and so you can read that too. I'm sorry, I forget the title of the book immediately, but that's a good book too.
Okay, thank you so much, ma'am. We've reached the end of our questions.
Thank you all, and good luck.
Thank you, ma'am. I would like to express my special thanks to Professor Masani, to our seniors, our conveners, Anushka and Nidhi, to my junior core, to my Assistant General Secretary Aditya, and to this audience for being patient and interactive and making this a successful session. Thank you very much.
It's a pleasure to be back. Take care.